Hi, this is Matthew Bell, and I'm from Alzheimer'sProof.com. That's Alzheimer'sProof.com. My dad, Jim, died from Alzheimer's disease in 2016. I took care of him for 4 years in his own home, and then he was in a nursing home for 4 years after that. Driving was a major issue in my dad's struggle. As soon as he was diagnosed with Alzheimer's disease, it became obvious that he wasn't safe to drive a car. But in my dad's case, he didn't want to give up his license. So it became a matter of me actually having to intervene. I had to write a letter to his physician, and his physician had to write a letter to the government to get his license revoked. Cases like my dad's raise the issue, what are the legalities of driving with Alzheimer's disease? And that's what I want to talk about today. It's a complicated issue, and I want to point out that I am neither a doctor nor a lawyer, so I cannot give medical advice and I can't give legal advice. Even if I were a doctor or a lawyer, I wouldn't be able to advise you or your loved one in your specific case. You need to consult professionals in your area who are familiar with the details of your particular situations. This then is for general informational purposes only. The basic question is, what does the law have to say about driving with Alzheimer's disease? I want to point out that there's a wide variety of complexity here. Each state, and in Canada, each province has its own particular procedures and forms. Go to the website, alzheimersproof.com, to find a state-by-state or province-by-province guide to help you get started. When we think of the question, is it legal to drive with Alzheimer's disease, the first thing we want to recognize is that Alzheimer's is a kind of an impairment, and it can be illegal to drive under an impairment. For example, we recognize it's illegal to drive when your blood alcohol level is beyond a certain point. But that raises the issue, not all impairments are equal. If I sprain my wrist, I have an impairment. If I am tired more that day than another, I am impaired. But whether that impairment is sufficient to rise to the level of that which would put you at risk of legal liability, that's not a question I can directly answer. But it is sufficient to note that driving with Alzheimer's disease or some other kind of a mental impairment can put you at risk of lawsuit. But the level of impairment matters. Just as in the case of being defined as legally drunk is having a blood alcohol content over a particular level, we have to remember that Alzheimer's disease comes in stages. The fact that a person has a diagnosis of Alzheimer's disease does not necessarily mean that that person is automatically too impaired to drive. Alzheimer's comes in various stages. There are many different ways of categorizing Alzheimer's stages. For a more complete exposition of this, see my website. But in general, we think of early, middle, and late stage Alzheimer's disease. The most important or critical time period in discussing these matters with respect to driving is probably not going to be early stage. It's probably going to be the transition between early stage and middle stage, or in general, just middle stage. By the time we get to late stage, a person is usually so impaired that they can't even walk by themselves, and therefore driving isn't even a possibility. But in early stage, it's also not vital to restrict the license in some cases, because all we're dealing with is very subtle memory changes, maybe some subtle personality changes. But again, you have to carefully address this on a case-by-case basis with doctors, lawyers, and other advisors in your area. But middle stage is going to be the most important stage with respect to this conversation, generally speaking. But the short answer is, yes, there can be legal issues, legal liabilities, and other things with respect to driving with Alzheimer's disease. When we're thinking about how an individual state or province addresses the question of whether to take a person's license, we have to recognize, first of all, that there are two very general scenarios. Scenario one is a renewal scenario. Scenario two is going to be a non-license renewal scenario. What do I mean by renewal scenario? In every state, you're going to have a different license period, a period of time where after you pass your driving test and get your driver's license, you're going to be licensed for a particular period of time. That could be 2 years, 4 years, 6 years, whatever it is, depending on your state. In some states, there are different renewal periods for people who reach certain plateaus. For example, at senior age, and that's variously defined, 55, 60, 65, 70, whatever it is in the state, it may be that whereas a younger person could have their license for every 4 years, now you have to renew it every 2. There can be restrictions like this. Generally, when somebody comes up for renewal, they're going to go into the driver's license office and they're going to be given a form. On that form is going to be a question something like the following. Do you suffer from any condition that might impair your ability to drive an automobile? Obviously, the answer to this question is going to be either yes or no. For the vast majority of applicants, the answer is going to be no, and it's going to be a legitimate answer. But there are any number of reasons why a person might answer no, even if the answer should really be yes. For one thing, a person might suffer from a cognitive impairment, and they might not realize that they suffer from that impairment. Or a person might be pretending to be healthier or less impaired than they actually are. Driving is one of the very important, in our society, sources of autonomy, and people, generally speaking, have a hard time giving the license up. If a person answers yes, they do suffer from a condition, then they will immediately be given over to some kind of a driver fitness unit or some kind of a medical evaluation board. That board will then make a determination based on medical records, observation, testing. But it's not usual for a person to answer yes. If a person answers no, it would be up to the driver's license bureau official to take a look and to see whether the proposed applicant is acting in a peculiar way. Maybe they seem to be confused or something else. If they don't appear to have any kind of cognitive or behavioral issue, and they have checked no, they suffer from no condition, then they would proceed to do whatever testing is required for that renewal period. It could be eye testing, it could be general knowledge testing, it could be a driving test. But if they pass those tests and they have answered no, and the driver's license official has not detected any reason to think that they might be putting on, their driver's license will be renewed. At that point, the second of the 2 ways that a person can be brought to the attention of the driver's license authority is engaged. The second way is via a report. There are 3 main people who can file a report. The first is going to be a physician, a doctor. There are actually 2 different types of state. There's a mandatory reporting state and a non-mandatory reporting state. Most states have non-mandatory reporting. What is mandatory reporting? Mandatory reporting would be where a particular state requires that a doctor who notices a patient has some particular condition, that condition and that patient must be reported to the driver's license authorities. All mandatory reporting states vary depending on what those conditions are. They're not always Alzheimer's. They could be some other kind of neurological disorder or something else. Once a doctor has reported a patient to the driver's license authority, then that medical review process would be initiated and the determination would be made as to whether or not to revoke a license. The doctor's opinion is very important in this kind of a process. In a non-mandatory reporting state, the physician or doctor is not required by law to report a particular patient or condition to the driver's licensing authority. But that does not mean that he or she will not do so anyway. There could be a number of reasons why a physician in a non-mandatory reporting state might report a person to the driver's licensing authority. One reason is an ethical commitment, that the doctor believes that the person might be a danger on the road to him or herself or other people, and feels a moral obligation to report the driver to the driver's licensing authority. Another reason might be professional affiliations. The doctor might be part of a medical group, and the controlling document for that medical group might mandate that the doctor has to report certain conditions or patients to the driver's licensing authority. A third possibility would be that the professional liability insurance for the doctor might also require that the doctor report. I should point out that even in a mandatory reporting state, for example, one where neurological disorders are mandated, it may be that a doctor might decide to report his Alzheimer's patient for one of those 3 reasons that we just described, even though in that state, Alzheimer's isn't required to be reported. A doctor's report is probably by far the most common sort of a report that the driver's licensing authorities will receive about a patient. But doctors are not the only people who can or will report drivers to the driver's licensing authority. Law enforcement officials may also report a driver to the driver's licensing authority. They might do that because they notice a driver acting erratically. They might report after a traffic stop or a traffic accident. Police officers can request that a particular driver be retested. They can also file a report similar to what the doctor can file that describes what they observed and just simply gives their concerns. The third category of possible person who could report a driver, let's just call it other. It usually is going to be family members or caretakers or someone who has an intimate knowledge of the person being reported. A person who would be able to provide name, social security number, date of birth, and have some knowledge of the health history. Some states allow other concerned parties to report a driver. This might be a general concerned citizen, it might be a friend or neighbor, someone who might not have all those intimate details but still knows enough. The requirement that the person have some knowledge of the reportee is there to protect people against the idea of a nuisance reporting or a revenge reporting, where someone cuts you off in traffic, you get their driver's license number, their license plate number, and then you report them to the Department of Motor Vehicles. In states where a non-physician and non-law enforcement official are allowed to report, generally speaking, it's going to have to be in the form of an affidavit. That is a legal document that the person signs, possibly with a notary or a witness, in order to make sure that the complaint is legitimate. There are three main outcomes to the medical review process, regardless of how it's initiated. It could have been initiated as part of the renewal of a driver's license or in one of the reports that we just discussed in a non-renewal situation. Those three outcomes are as follows. It might be that the medical review process recommends that no action be taken and that the person who is reported doesn't lose the license and has no restrictions. It might be that the concern was found somewhat credible, and instead of revoking the person's driver's license, it might be that certain restrictions are put in place. Those restrictions might be restricting the person to driving at particular times of day. No night driving, for example. It might be that the person is restricted to driving certain distances, maybe within a certain distance from the house, or to a doctor's appointment. The third outcome might be that the person's license is terminated or revoked. This is obviously the most serious. If the concern is found very credible, the person has a severe impairment, this would be the recourse. Many states, depending on the procedure, have an appeals process. If the family or the person believes that he or she has been given an unfair hand, they can actually escalate the matter, generally speaking, to an appeals process. How that plays out is going to be dependent on the state. Again, consult my website, which is not an exhaustive guide, but it will sort of give you a general idea of who to contact to ask further questions. The states vary widely. The provinces in Canada vary, maybe not as widely as in the States, but they do vary. Again, on the website, alzheimersproof.com, you will find a state-by-state and province-by-province guide for the United States and for Canada that gives you an idea of how to sort of do research with respect to the legalities of driving with Alzheimer's disease. I appreciate your time today. I hope that something that I said may have been of use to you. Once again, I'm not a doctor or a lawyer, and I can't give you specific medical or legal advice, but this information has been presented in good faith just as a recollection of experiences and research that I've done, and I hope that it may be of some use to you. I invite you to visit my website and also come back to this YouTube channel as I update it with additional content. Thank you so much.